Good morning, everybody. Happy day. Welcome to the City of Griffin Board of Commissioners September 24th workshop. Call the meeting to order. First item is to discuss proposed amendments to the Code of Griffin, Chapter 6, Alcoholic Beverages. Staff Attorney Kelsey Carden will present. Welcome.
Wobble up.
Don't you dare.
No, I was reading something.
Uh-huh. Good morning, everyone. Other than Commissioner Ford. Okay. So while we work on getting that presentation up there, I wanted to let you know that this is a little bit longer than I normally like to present to you guys, but I am trying to make it as comprehensive as possible because we are trying to have the first reading and second reading go in October so we can get these changes adopted and have this apply to our calendar year 2025 alcohol licensees. And so if we fail to do that, then we're going to be in a position where some licensees within the city are going to have to abide by the prior rules, and some will have to abide by these new rules because of the grandfathering issues. And that doesn't apply to all of these provisions, but it does apply to some of them. And so we're just trying to make sure that it's easy for enforcement, not just for our tax and licensing staff, but also for the police department, determining what obligations these businesses have. There we go. Okay, so beginning with the intent and purpose of this code. So this provides for licensing and regulation of the manufacture, sale, and consumption of alcoholic beverages within the city. Chapter 6 has not been substantively amended since 2017, other than some of the amendments that we have done following state law adoption, specifically the brunch bill, which changed the operational hours for eating establishments, allowed them to open at 11 a.m. or allowed them to serve alcohol beginning at 11 a.m. So the basis for these regulations, and I think it's important to keep these in mind, is our police powers, the promotion of health, safety, general welfare, and peace, and ensuring the responsible distribution and consumption of alcoholic beverages. So in addition to speaking with our tax and licensing folks about what are you guys experiencing at the application stage? What information do you need to make sure that we're holding everybody to the same standards? How do we make this easier for individuals who are looking to open a business within the city and make sure that we're driving economic development and balancing that against what our police department needs, what they're seeing by way of enforcement. And this goes for packaged retailers, eating establishments, as well as bars and public clubs that may be within the special entertainment district. So the current classifications are really divided into two parts. You could argue three, but the main kind of focus is going to be two parts: on-premises consumption, and that's where you can drink alcohol, order alcohol at a location and consume it there. So those are going to be your eating establishments, public clubs, bars, fraternal organizations or private clubs, hotels, alcoholic beverage caterers, brew pubs, and the city golf course. So brew pubs are actually a combination of a manufacturer, think about Piedmont, where they're manufacturing the alcohol that you can consume on site, and then they're also an eating establishment, and that's required by state law that they're going to be an eating establishment plus a manufacturer. And so that brew pub designation is really a combination of those two. And then you have package sellers, which are your wholesalers, your individuals that are picking up from the manufacturers and distributing to our package stores, distributing to our retail establishments that are selling, for consumption at home, as well as our on-premises consumption dealers. And then you have your manufacturers, so distilleries, they make liquor, breweries, which make beer, and then wineries, which make wine. Your retail package dealers, which are your package dealer retail stores, your convenience stores, grocery stores, and things of that nature, as well as specialty package dealers. We don't have any within the city at this time. There's a very specific definition, but you can imagine a wine and cheese shop that also operates as a deli where someone can come in and order very special or unique food products that are not intended for consumption on premises. And they can also find unique wines or beers that may also be sold there. A lot of times these places will also sell unique kitchen appliances or cheese boards or things along those lines that you may see for parties and things like that.
Yeah. Didn't we once have on our books a shops and beauty salons that serve wine.
Not to my knowledge. Drew, do you have any?
We,
Yes.
And I think we did agree to the license service of wine, but they've got about a city law.
Yeah.
Same way with
They
like
do it on their own.
And I'll be honest, I don't know that even if we applied it that way, they may have previously fallen under the public club designation. What we would be recommending here would not apply to those. And I don't know that there has ever been a definition in our code that
anybody
would have
ever apply
supported
for
that.
but like theaters, the situation was up like Main Street Players and stuff like that. They would have to get up.
Those would fall under
Right.
public club. And no matter what, if you're distributing alcohol within the city, you have to have a license.
Main Street players, don't they buy a license?
And they would currently fall under the public club designation. We'll get into what those definitions currently are and what we're recommending to change them to. I will go ahead and let you know off the top that the framework that we are currently presenting would not include barbershops and hair salons. There's also been a question about boutiques in the past because there are some places, for example, that sell wedding dresses in other jurisdictions that would like to be able to sell champagne or wine or serve champagne and wine. And at this point, based on the police force that we have and the enforcement issues that they have had, really the risk of abuse and then the staff needs that we would have for enforcement of that, it's just not supported for our jurisdiction right now.
When you say sell and serve, they would have to have a license even if that was what they wanted to serve wine to their clientele.
Yes, even if they're not selling, and the rationale is that they would have to purchase something because you can't give away alcohol for free. So the only exceptions to that are tasting events and things of that nature where you're buying a ticket. So most of these boutiques have to have some sort of tie-in, but under our current framework, you cannot provide alcohol for free. And I wouldn't recommend that again with our current police force that we have, the current staffing that we have, the problems that we have with the fact is that the city is one of very few jurisdictions of our size that actually allow bars. And so we have bars downtown, and that takes a huge amount of police work and monitoring as well as the tax and licensing work to keep track of that because of the parameters for these definitions where an eating establishment, again, we're going to get into this, but is a 50-50 of food versus alcohol. Your bars are 75% alcohol and they're actually not required to serve food. And so because we already have those at this point, it's already a struggle for that enforcement. And I would not recommend expanding that to to any other mercantile business that's just looking to sell a product, simply because of the risk of abuse at this point. Now, if we were moving along and had really had no issues, and our police department said, yeah, we think that we're ready for this, then I might make a different recommendation. But we have collaborated again with Karen and her staff and the whole of planning and development, as well as the police department. And at this point, I don't believe that that's something that we're ready for. So these current classifications, this gives you an idea of the current definitions. So that's eating establishment, which, as I just mentioned, is at least 50% of total annual gross sales from prepared food and meals, which means that the other 50% or less would have to come from alcohol or could come from alcohol. Brew pubs are an eating establishment where malt beverages are also manufactured, and barrels and package sales are excluded from that gross sales calculation. So for Piedmont, they would not count the alcohol that they sell to wholesalers or barrels that they sell for off-premises consumption as part of that 50%. They're only looking at what they're selling on premises. And then a bar is 75% more annual gross revenue from the sale of alcohol on the premises. It is only permitted in the special entertainment district. And then public club, which is where you're going to see the majority of the change here, is defined as other than an eating establishment or bar, so not meeting the definition of an eating establishment or bar. And the principal purpose is live music, dancing, theatrical productions, or comedians, and alcohol consumption is incidental to that underlying business. Okay, so that's how we have situations like Opera House, currently Stash Studios that offers art classes where they're offering a service, also have the ability to sell alcohol as part of that service that they're providing. The idea there is art education, that it's actually like a recreational activity Same thing with putt and pour, where you're tying that to a recreational activity. And when Georgia Acts was here, the same thing would apply. So you're really looking where you're coming for a recreational or art class or art education or theatrical production show, and drinking alcohol is incidental to what you're really going to that property for. Okay, so that's kind of the framework and how we've applied it. In my opinion, that public club definition is a little misleading. I think that when people hear public club, they think nightclub. And a nightclub, on the other hand, is not where you are going for the purpose of experiencing a show, solely to experience the show. You're going to drink. That's the primary purpose of going to a nightclub. And so we're trying to make sure that really, in my opinion, if something wanted to call itself a nightclub, in reality, what we're really looking at is that it's a bar. It's serving 75% or more of alcohol. That is the primary function for which it exists. Alcohol consumption is not incidental to its primary purpose. So
okay, I want to go back.
Yes.
To that. Okay. So the VFW
Yes.
on North 3rd Street wouldn't be considered. It's not considered
The
a public club,
VFW
which it has always been called.
The VFW is considered a fraternal organization or private club. So I'm going to go back to this slide because I did miss this point. These highlighted portions are where we're going to have changes. So that's where I focused my attention for purposes of these classifications. No other changes are being made to the other classifications. So the VFW would still fall under fraternal organization and private club. We would still have hotels as a designation. We would still have alcohol beverage caterers as a designation. So our places that want to operate for events such as HCH, rather than they would not have a designation for their own alcohol license, but they would be permitted to obtain or hire one of our alcohol licensees to obtain an alcohol catering permit so that they could serve for that particular event. And then brew pubs, city golf course, wholesalers, manufacturers. And then I put retail package because there's small changes that are happening with regard to the sub definitions here under retail package, specifically with regard to their inventory, as well as the distance requirements. And so these are the 4 primary classifications that are going to be experiencing change as part of these amendments. But the VFW would not change. So the main changes that you're going to see here are eating establishment is pretty much going to remain the same. Bar, we are going to add the provision that serving of food and live music entertainment, so that they are allowed to have live music, is only incidental to the consumption of those beverages. So again, the primary purpose and function of this type of establishment is going to be the consumption of alcohol. Public club is going to be removed, and instead we are proposing that it be replaced by a more substantive definition for art and recreational entertainment establishment. So an art and recreational entertainment establishment is going to be defined as, I know this is a long definition, so bear with me, an establishment that is not a restaurant, I should put eating establishment, or a bar, deriving at least 50% of its total annual gross sales from the sale of art/recreational activities and merchandise and or food, having the principal purpose of offering art and recreational entertainment to the public, including live music, theatrical productions, art shop classes, education, comedians, and leisure activities, and wherein the sale of alcoholic beverages is incidental to its primary enterprise and activity on the premises. So this is really just shoring up some of the things that we already had in public club, but we're taking it a little bit further. The primary activity on this premises needs to be family-oriented in nature, meaning it's a use which attracts a range of individuals from all age groups. Establishments for which the primary purpose is to provide a rental location for hosting entertainment, art events, music or theatrical shows, or other events are specifically excluded from this definition. The idea is that if you have a place where the primary function or the primary activity is going to change, because you could rent it out to a business that does art shows, art exhibitions, or you could rent it out to someone who wants to do a teen club night or some other club night. If your use is varying, it makes it very difficult for our police department to be able to keep track of what's there, and requires a lot of staff resources to communicate those things in advance. Yes.
Shoal Creek Golf Course, does it fall under city as well?
It's within our jurisdiction, so I believe that at that point it could potentially go for a private club. They have a restaurant? Okay. And so that's the other thing to keep in mind. Even though they may do all of these things, if they have a restaurant on site and 50% of their sales are coming from that, then from the food and beverage, non-alcoholic beverage sales, they can qualify as an eating establishment. And sometimes that's preferable because the eating establishment license fees are actually significantly lower than they are for public club and bar. And that's because there's more complicated enforcement. So those individual or those groups, such as event centers that I was mentioning, would be able to get a alcohol catering permit, which means that they would get on board with a license fee that already existed. And so at that point, we can start holding those licensees accountable if they're violating any of the rules of this ordinance because they have a license within the city. If we were to just award it to an event center and that event center has different promoters or individuals coming in who are doing these events, it makes it very difficult to make sure that we're communicating with the right person who's running the show, who's responsible for the invitees that are on the premises. And it makes it very complicated for the police department to be able to respond because they don't know at any given time what's going to be operating out of there. So limiting those to catering permits allows us to be able to ask more in-depth questions about the event and allows the police department to know in advance what's being conducted there. We wouldn't have that if they had a carte blanche alcohol license. So bingo parlors, dance halls, nightclubs, billiard parlors, skating arenas, adult entertainment and or sexually related entertainment activities, event centers, banquet halls, and similar uses are specifically excluded from the art and recreational entertainment establishment definition. This is actually an exclusion that is taken from other jurisdictions. Sewanee is a really good example, but other jurisdictions also have that allow for this art and recreational entertainment establishment provision, which is not a lot of them. Also exclude those. And the intention is that these are the ones that you're usually going to have issues out of. You want this to be something similar to what we have for Putnam-Port or Georgia Axe, where you're truly going there to have a particular experience. It's intended to be family oriented. I could bring a baby into there if I wanted to and not have to be concerned that we're going to have rowdy issues. There's also no intention of gambling sort of on the underside of things, which is why you want the exclusion of billiard parlors and bingo parlors because that can, be considered a gambling, and so you have people drinking, and that becomes a concern. And lastly, the establishments shall not be operated or conducted in conjunction with any other mercantile business, trade, or profession, and may offer and sell only those items associated with its primary activity. So what they tell Karen they're doing on their OTC should be the service that they are providing, and they can sell merchandise associated with that, but they should not also be selling cigars or things unassociated with their type of establishment. Okay. And this is also going to be limited to the special entertainment district. Again, we're really just subbing in, going from public club to art and recreational entertainment establishment to make sure that we're shoring up the type of business that we're providing that to and clarifying what public club is not. And that's going to be those nightclubs and things like that. They're going to be classified as bars. So now into the more nitty-gritty. License qualifications. So currently, all applications for licenses have to be in the name of persons who will own and operate the licensed business or the business entity which will own the licensed entity. There's sort of a slash there because you also have to add an agent, and the agent has to be involved in active management and has to meet all the application requirements, including fingerprinting. None of those things are specifically changing, but we're talking about this from an enforcement perspective, and I'm really noting this for the record for our alcohol licensees because there will be a separate form they're having to fill out. So no original or renewal license shall issue if any individual with an interest in the business or their spouse has been convicted of a felony in the last 10 years or a misdemeanor except for traffic violations in the last 5 years. The city manager does have the right to be able to waive that misdemeanor section based on factual circumstances. So the recommendation here is just enforcement, and we're not really changing anything, but we are changing the application for enforcement of that interest holder information. So previously, if we had someone who was denied because they had a felony conviction in the last 10 years, they would just sub in their partner, or I guess I should say member, because partners both have to apply. So if you have an LLC, they would just sub in their business partner who's also a member of the LLC and obtain it in their name. And that was a workaround. So we're requiring them to give us their interest on paper and telling us who has an interest in that business, and we're enforcing that. Now, we are still only doing the background check and the fingerprinting per state law, against the agent who is going to be listed on that license, the primary person who has to meet the applicant requirements. But we are making them certify on an affidavit, sworn oath, that there are no other interested parties in that business who would violate this. So if we find out in the course of an investigation that happens on that premises that that is not the case and that they lied on their application, it's cause for automatic revocation. Okay?
Question, is that on every level for restaurants?
Yes, every level.
Every level.
And we are also going to remove the spouse conviction because I think that's very difficult. There are situations where people can go through a long and laborious divorce, and I don't think that it serves our function if they are tied up. I mean, you may have a business where the spouse is tied up in that business. I don't think that it's our position, nor should it be Karen's position, to have to ask personal information about whether or not the judge is letting the spouse out of the business so that they can continue to operate, or any of those types of questions. Instead, we're just replacing it with the requirement that if the license is denied, the spouse cannot be substituted as the applicant or agent. So if a husband applies, they have a felony conviction, and we deny the application on that basis, they cannot substitute their wife as a means of getting around that. But we're not going to be saying that the spouse who isn't even affiliated with the business is not going to be, can't have had these convictions. Sometimes that's why people get divorced. So we're not getting into people's personal business in that manner. This is a standard. The removal of the spouse provision is a standard. We went through several jurisdictions looking at their alcohol codes, including Athens, Columbus, Savannah, Woodstock, Dahlonega, Noonan, Stockbridge, Carrollton, and then recently added Thomaston, Commerce, Sewanee, and Clayton, Georgia, as well as Clayton County. And we're able to kind of get this cross-reference. And so everything you see here is really supported by multiple counties and then engineered towards the needs of our city. Other counties and municipalities. So application and renewal submission, the deadline and the fee. Currently, applications for renewal are due on or before November 1st, and they must include a $150 non-refundable deposit. This covers the cost of investigation. If the application is granted, then if they owe, let's say, $1,500 for their alcohol license, it's $1,500 minus the $150 they already had to pay. And then the annual license fees are not due until January 1st. Well, the concerning part is that if you don't pay by January 1st, your license has expired and we're required to automatically notify DOR. And it's only after January 1st that they have that penalty. And that makes it very complicated for Karen when you're getting around the holidays when we're coming in at the 11th hour to be able to pay their permit fees. And it also makes it pretty much in limbo where we can't tell the police department whether or not these people can operate on New Year's Eve, whether or not they can operate on New Year's Day. And so we're recommending that we keep the same application deadline, with the exception of this year, which has been expanded by resolution of the board approved at the last meeting. And we're requiring a full alcohol license fee be paid in order to consider that application complete. So they're going to be required, if it's a $1,500 alcohol license that they're applying for, they're going to be required to pay that by November 1st. If it's denied, they'll be reimbursed all but that $150 investigation fee. If it's granted, we don't have to start chasing them down around Christmas and New Year's trying to say, where are you? Where is your payment? And we don't have to start notifying the police department, hey, this business can't operate, nor do we have to run the risk of us violating state law by failing to notify the state that their state alcohol license would also have to be revoked if they failed to pay by that date. So this just cuts down, it's from a staff perspective and then also from a police department enforcement perspective, cuts down on that issue. We are also recommending that if they fail to submit a renewal application or by November 1st, that there's a penalty of 50% of that license fee that's going to attach. That is the same penalty that currently applies, but currently if they fail to pay after January 1. And the issue there is that really, I don't know that we would even consider that a renewal, because after January 1, you have no license. Your license has expired. Your business is over. And we need to be able to consider that business over at that point and require that they submit additional application requirements after that date if we need to.
What is the percentage of businesses that are establishments that are using business licenses that are not renewing?
Timely? That's a Karen question.
So is that like big restaurants or, you know, what kind of,
And Karen has taken efforts to begin this process starting in like September, where she's sending out packets. So it's not something that just sits in our code. She is actively for months leading up to this, contacting these businesses, sending them information by mail, notifying them through our system in iWork if they have email that they need to renew. And that is still not working. And so it makes it very difficult for them around the holidays because Karen has to be mindful of that if she's planning on taking time off for the holidays, that she may have someone come in and another planning and development staff person may have to, gather up all of the information. They've done a very good job of streamlining their processes internally within that department so that everybody can do that job if needed. But it is very difficult around the holidays that you have all of these people swarming in to pay something that really they should be paying by November 1st. You should be applying by November 1st. And if you're not, we're hoping that this penalty will act as a deterrent and prevent that behavior in the future.
so what we're doing is changing the deadline from January 1st to November the 1st.
So their deadline for the application, no matter what, is November 1st. But if they fail to apply by November 1st, there's essentially no penalty because the penalty does not accrue until January 1st because their fee isn't due until January 1st.
Mm-hmm.
So it's very, in my opinion, it makes no sense to have the fee due at a different time than the application because if there's no penalty, there's no deterrent. And so someone is going to wait until the 11th hour. The only deterrent is that after January 1st, we notify the state and their state alcohol license could be in jeopardy. But that doesn't get staff around the obligations have to go through the effort of notifying the state and providing them with all of that documentation. And again, that's occurring right after the holiday. And we have to notify them immediately because our police department, January 1, January 2, may have to go and tell that business you have to close your doors. Because
So, are you saying that you want to change the date push it back to November?
November 1st is when the fee will be due and when the application will be due.
Okay, that's the deadline.
Yes, that will be the deadline. Deadline to pay, deadline for everything. Now, that doesn't mean that their alcohol license is renewed for the following year on November 1st.
Mm-hmm.
It just means that we will review, and then if it's granted, we already have their license fee. We don't have to track them down. If it is denied, they will get reimbursement of all but that $150 application fee.
Okay.
So in that same vein, required documentation. So our alcohol code is not the most organized. This leads to confusion for the applicants about what's required and can create some frustration. But it also leads to confusion from an enforcement perspective. We have the police department who, annually is going through and looking at these applications, and the police chief is reviewing, the documentation that's there. But they're not in that code all the time. Karen is in there a little bit more than they are, and they're really just looking at this at the end of the year. And so I would like to create a list, and this will be a code section that's added in, that is a mix of everything that is sort of just strung throughout the code in random places that says this document is required or you must swear to this statement, and make a comprehensive list just to make it easier. But in addition to what is already there, I would like to add a proof of planning and zoning compliance form. So right now, a certificate of occupancy is required. But for most of our downtown businesses, for example, you may have a building that already has a CO. It's had its CO for 100 years. And we haven't had a reason to revoke it, and so it still has that CO. So requiring a certificate of occupancy does very little to ensure that the building is fire compliant and that the building is building safety and construction compliant. And so what we're going to recommend is to do or require a certificate of completion, which is required for any rehab type work, or some other record or proof from the building official and the fire marshal that their current use, including the occupancy load, is permitted and that the building meets required codes. Now, we do this for the fire marshal, but it's a little bit, it's less official and it's sort of separated from the building requirements. We currently don't have a mechanism for getting our building official to go into that to say, here are the code violations that exist, unless there's no CO, unless it's a brand new building, or unless they currently have plans for a rehab of property. And so we're just wanting to get a form that they're filling out where our building official has gone in, our fire marshal has gone in, the specific occupancy load is noted on that one paper so that it's very easy for everyone to reference. And it makes it much easier if we do have a problem for me to be able to reference in municipal court. So I'm also requesting a form that's signed by a designee, by the chief of police or designee of the City of Griffin Police Department, certifying that the security camera system that is on premises complies with the requirements set out in code. This is required that when it's initially put in, that we have to certify that this system is compliant. And by certify, it's really just a thumbs up. Yeah, they're good to go. We're going to formalize this a little bit, and we're going to include it from an annual perspective as well, that someone from the police department is going to go by once that application is received. We're going to look at the cameras. We're going to make sure that we have the ability to be able to pull this footage off, because what happens is that a crime occurs, the police department shows up, they ask for the video, and someone says, oh, well, we don't use it that often, we don't really know how to pull it off, and it may take us a couple weeks. Well, a couple weeks at that point is eating into their ability to be able to solve that crime, and that's the purpose for which these security cameras exist in the first place. Next is distance prohibitions. This one's a little bit of a unique bird. Currently that we impose the state law distance requirements, or we don't impose the state law distance requirements for on-premises consumption for government-owned and operated alcohol treatment centers. I apologize. We do impose it for alcohol treatment centers and the housing authority properties. We do not impose the state law requirements for churches, schools, and colleges. We're within our rights to do that. That's perfectly fine. But we also include the provision in there that they cannot sell malt beverages or wine by sealed package for carry-out purposes if it's within the prohibited distances from the churches, schools, or colleges. Now, the issue that I have with that is that those same on-premises establishments, by state law, have the ability to be able to sell a bottle of wine, uncork it, pour some out and provide it, and then charge a recorking fee and let you walk out with an open bottle of wine under state law and put it in your trunk to take it home. The state law was implemented because people were drinking entire bottles of wine because they bought one. And so it was really a mechanism to say, you don't have to finish it here just because you ordered it. We can recork it and you can send it home. State law also allows for those on-premises consumption places to be able to sell malt beverages and wine by the package. So if they have a unique wine provider, they have the ability to be able to sell those. But under our restrictions, if they're within that distance of churches, schools, and colleges, they're not permitted to do that. There's no ability for us to prevent them from doing that corking fee unless we just ban that altogether. And it really is a contradiction. I don't think that it makes sense to be able to prevent someone from selling a opened or letting someone open a bottle of wine and leave the premises near a school, church, or college versus letting them seal a sealed bottle of wine or package of beer and then take that home. So we're asking for that to be removed. Also, providing a definition for housing authority property and school. This is defined in state law. We will be using that definition, but I will personally tell you that anytime I get questions about whether or not this is in violation, I have to go to the state code, which is not very organized, and it's not much more organized than ours is at times. So I have to go looking for it every time, or we have to refer a person who's applying for an alcohol license to be able to go look for it in state law if they want to confirm what my interpretation is. So to prevent that from happening, we want to be able to put that in our code. Next is location restrictions for package sales, as well as inventory requirements. So currently, there is a minimum wholesale inventory for package stores selling distilled spirits. So really, truly, your packaged liquor stores of only $50,000. In looking at this inventory requirement for other locations and other jurisdictions, the inventory requirement is for Dahlonega, $500,000 for wholesale, $750,000 for distilled spirits, and $35,000 for malt beverages and wine in Noonan, $300,000 in distilled spirits, and $15,000 malt beverages and wine in Stockbridge, $300,000 in distilled spirits, and $15,000 in malt beverages and wine for Carrollton. So we are significantly low, and I really don't know the cause or reason for that. But especially in light of inflation and the fact that we're not talking about a grocery or convenience store, we're talking about a liquor store that's selling distilled spirits, and those bottles obviously are very expensive. $50,000 is a very low number, and so we're asking for that to be increased to $150,000 for their inventory. We're not separating out distilled spirits and malt beverages. It's $150,000 for the entire store, so that if they specialize in a particular brand, we're kind of noting that they have the ability to decide kind of how they come up with that inventory, but it does need to be increased. Currently, there are no new licenses approved that are within 500 yards of any other business that's licensed to sell packaged distilled spirits. We're wanting to increase that to 1 mile. This is supported by other jurisdictions. The 500 yards is very common, but in light of us not having a distance requirement for our convenience stores and things like that, we're not at a shortage of places to be able to find alcohol. And a lot of other jurisdictions that do allow that 500 yards requirement also cap the total number of these stores that can exist. So they may only allow 2 or they may only allow 5 in jurisdictions much larger than ours. So I believe that this 1 mile requirement is going to be sufficient to do what we need to do.
Can you do a survey for us on all the existing with the miles circumference and see if that allows any more stores in our jurisdiction? That pretty much would.
Yes, and again,
Future
it will only matter. I can have Karen pull that and see what we can come up with GIS. But these will be grandfathered in. So if a business does close, then at that point they will be, they will have that opened up. And closed, we'll get to this later, is actually going to be closed for 60 days. Currently it's 6 months for some reason. And so we're changing that to, I apologize, 90 days, not 60 days, because 90 days is the standard that seems to be across the state. I'm not sure why we're provide more time for them to be able to close to keep that. But yes, we can get there.
Development, it is keeping anybody from ever coming to the city into the package store.
Yeah, and it wouldn't be any package store. It would only be package stores for distilled spirits. So to keep that in mind as well. Yeah. Yeah, so it would allow for convenience stores, and it would allow for grocery stores and things that places that sell beer and wine, but it would not allow for a pure package store that is within 1 mile of another. Yes, but we can have GIS and Karen get together to come up with a map to present to you guys. Okay, and then lastly, the convenience store. Currently, the inventory for convenience store is set at $10,000. This is food and grocery items, excluding tobacco, alcohol, and candy. Again, we're significantly lower than other jurisdictions in this regard, and I'm unclear on why. So we're looking at changing that convenience store inventory requirement to $20,000, and I think that is more than supported by inflation. In fact, majority of the ones that qualified at $10,000 likely qualify at $20,000 as of right now. So additional requirements for package stores. There are currently no additional requirements other than the bare bones that would be required of any other alcohol licensee, other than the security cameras. So we are proposing that the exterior of each package retailer must contain sufficient lighting so that all sides of the building and all entrances are clearly visible. This is currently required for bars and public clubs, which are downtown, but it is not spelled out and required for a package store. So we're wanting to put that into the code to make sure that they have sufficient lighting. Each store shall be lighted so that the interior of the store is visible day and night. You'll see this in a lot of convenience stores where they'll leave the lights on or like the sub lights on so that you can see within the store. This allows patrols of our police department to be able to determine whether or not a robbery is actually taking place. But one of the issues that we have is we currently have a lot of our package stores of all varieties that put so many advertisements or blinds or other sorts of obstructions in their windows that it is impossible to see inside of those establishments. And so we are wanting to add a provision where no screens, blinds, curtains, partitions, articles, or other things shall prevent a clear view into the interior of any retail package store, including advertisements in the window that are going to obstruct that view to the inside. This is something that is included in a lot of jurisdictions. I printed out a very small, in order to fit them all on here, it's very small, so I'm having a hard time finding everything I need to find on here quickly for you guys. But this is a very common requirement, which is why in other jurisdictions you may drive down and you may see convenience stores at 4 o'clock in the morning that may be closed where you can see into the store, and it's really intended to be a protection from a patrol side to make sure that we can see if a crime is actively occurring. But we can't do that if we're being blocked from view. This also makes it where a lot of the establishments will put these types of things up with the intention of hiding the lottery machines or things along those lines. So this is really a safeguard to make sure that we have the ability to enforce and we know where to dedicate our police attention if needed for businesses that are currently violating our ordinance and state law. Delivery of package sales. So currently, we have a provision that says no package dealer shall make or allow to be made deliveries of alcoholic beverages beyond the boundaries of the premises covered by the license. That provision has not been enforced, in part because of the difficulty in enforcement. Around COVID, there was a state law that was implemented, OCGA 3-3-10, and that allowed for grocery stores and package stores to be able to make deliveries with very strenuous requirements for the person delivering to be able to check licenses, as well as the ordering requirements and confirmation requirements. So it was intended to be a mechanism for COVID that has sort of taken root and taken off. And I want you to realize that if you order curbside delivery, and you have someone who you order wine as part of that delivery through Walmart or any other establishment and they bring it out to your car, that is something that is permitted because of OCGA 3-3-10. Okay, so if you order through Instacart and it gets delivered to your house, that is something that is permitted because of 3-3-10. Right now, I'm being very candid, that hasn't been, our provision not allowing it off the premises hasn't been enforced. So we've essentially been operating as if 3-3-10 is applicable within our jurisdiction. After speaking with our I'm sure if we're okay. So the state law does allow us to opt out of this. At this point, after speaking with the police department, they believe that really allowing it is probably going to be the best thing because in truth, they're not sure how they would enforce it. So if we did attempt to enforce it, we may have someone say that we're only enforcing it against them and not enforcing it against other businesses. It would be very difficult for them to be able to enforce because it's allowed throughout state law, and businesses have grown accustomed to it. Citizens have grown accustomed to it. So we're just really wanting to solidify that and add except as permitted by OCGA 3-3-10 so that we're imposing those requirements. I believe that ATF has also been involved in enforcement for provisions like this for other states that have done this enforcement. So if we realize that we do have a problem and there needs to be some sort of sting, or we think that there's a particular business that's violating the rules here under state law, we can contact our state partners and try to work that through our police department. But I think that including it, it's sort of us getting in line with the times. And the police department also made a good point that allowing someone to have it delivered to their home may prevent them from getting onto the road and driving intoxicated to go pick up additional alcohol. If they can have it delivered, it may result in saving lives and less DUIs. Next is indebtedness to the city. No license issued if any person holding a beneficial interest in the business owes any delinquent taxes or assessments to the city. I'm wanting to expand this. I don't think delinquent taxes, which would generally be excise taxes as well as property taxes, are sufficient. I want to add court fines, costs, and other outstanding debts to the city so that we can look at that interest list that we're now requiring them to put onto an affidavit. And we can look through and determine whether or not we have any outstanding nuisance issues, any outstanding code issues, any outstanding traffic violation citations where they failed to show up or failed to pay, as a means of making sure that if someone is making money within our jurisdiction off of our citizens, that they are also, complying with the debts that they owe to the city that are being enforced for those citizens' benefit. This is something that we require for all of our alcohol permits. For all of our building licenses. So I think applying it to alcohol permits makes sense as well. So consideration of granting licenses. I'm going to kind of try to skim through this one to move it along, but I really wanted to put it here for just your review, and I can give you copies of the presentation for you to look at in more detail. So currently, the city manager has the duty and authority to determine whether or not an application can be granted. We can look at the need for excessive police intervention, and that can be based on history at a location, anticipated effect on the surrounding neighborhood, including traffic congestion, noise, and or light, as well as other interested parties that have been cited for violations related to operating these types of establishments in the past. And it provides the city manager with a discretion and option to do a probationary license, but it only specifies that it's conditioned upon a $5,000 bond. In my opinion, a probationary license put onto a bond does us very little good. We don't need the money, we need compliance. And so I think that putting into this a process that allows us to do probationary licenses with specific action plans, including adding additional cameras if that is needed, adding additional lighting sources if that is needed, adding additional security if that is needed, that makes more sense than just requiring them to pay $5,000, and if they violate it, we get $5,000. That doesn't serve the function that this was intended for. And then as part of that process, although we're allowed to consider those standards, I want to expand that a little bit to note that we can consider CAD files, calls for service, police and fire response history on those renewal licenses, timeliness of the payment of excise taxes. So if a business has to pay an excise tax and they are routinely late every single month, we can start issuing notices of adverse action, giving a warning saying that we can consider revocation or suspension, temporary or otherwise, or probationary license if they have a history of failing to pay us. And that's a deterrent intended to make sure that everybody's playing by the same rules. We also, as part of those specific action plans, would allow for a waiver of future revocation and suspension hearings. If that action plan specifically is violated or not complied with. That's something that has support in other jurisdictions, and so we'll kind of be pulling language from there. And then including that certificate of completion for buildings, which I previously mentioned, in order to prove compliance with building and fire safety codes. So if they have a bathroom that, and this happens quite often with some businesses, if they have a bathroom that does not work, and we hear from citizens that their bathroom is continually out of order, so if you order drinks there, you have to walk to another establishment that they have an agreement with to go to the bathroom. At that point, you're getting a notice of adverse action, and we should be able to, make your action plan fixing that problem and showing our building official that that problem has been fixed, it has been repaired. Likewise, with leaky ceilings or other mildew concerns, if we are to receive complaints, it should not be that shutting down the business is and revoking the CO really is the only mechanism we have. We should be able to target this alcohol license because having one is a privilege. So we're wanting to utilize our leverage to make sure, or utilize our leverage that we have with licenses to make sure that these businesses are complying with the same requirements we would require of anyone else, and that is on par with the privilege that they're being granted. So license and permit fees, this is increases. We have, thanks to Karen and Savannah, gone through other jurisdictions and looked at their amounts and figured out that we are on the lower side. In some areas we're more consistent. So this does not include all of the current fees. These are only the fees that we are looking at changing. So currently eating establishments, wine tasting rooms, and hotels have a malt beverage and wine license of $500. We are asking that malt beverages and wine license be increased to $750. Public clubs and bars have a malt beverages and wine license of $1,000 and distilled spirits of $5,000. We are asking that those be kept the same, but we're noting that bar is going to remain the same, but the art and recreational entertainment establishment is going to replace that public club, but the fees are still going to remain exactly the same. Private clubs and fraternal organizations, so this would apply to the VFW. Malt beverages and wine are currently $350 and distilled spirits are $1,000. We're asking that the malt beverages and wine be increased to $500 and that the distilled spirits be increased to $1,500. The other jurisdictions with regard to private clubs, let me see if I have the actual fee amounts, are significantly higher than ours, some of them reaching close to what we actually have for bars. And so a good example is Stockbridge has a $5,000 distilled spirits requirement for private clubs, and Sonoya has $2,500. So we are still going to be significantly lower at $1,500, and we're just wanting to make sure that this is commensurate with the amount of time and administrative effort that's put into management for these locations. Their applications are actually more complicated because they do have to provide us with lists of members and show that they're complying with certain requirements related to their membership and their dues paying individuals. And so we're wanting this to capture that we are having to spend a little bit more time than we would on an average application related to private clubs and fraternal organizations. And then for alcohol beverage catering, we're asking for an increase in the event permit from $25 to $50. This is per day for each event with a 3-day maximum for these events. Part of the reason for this is that we realize that there are some establishments that were abusing the system, and we're hoping that this helps to assist and level the playing field a little bit, where a bar may be required to pay $5,000 for a distilled spirits license to allow them to sell alcohol, but then another location would just utilize the event permits. And if they only conducted themselves on the weekends and you added that up throughout the year, they are paying less than what the bars would be paying. And so this is intended to really capture that and make sure that we're leveling that playing field for our brick and mortar bars versus our establishments that dabble in alcohol, is I guess the best way to put that, only for when it serves their function or serves whatever event they're wanting to put on at the time. So we're just trying to prevent that abuse. This is not airtight. We're still looking at other ways to be able to make that happen, to be able to prevent that from happening. But right now, this is the best thing that me and Karen could come up with, and we're going to see how it works and whether or not this acts as a deterrent. But in the future, we may have to put in event permit restrictions, so put a cap on the quantity that they can have within a year, within a time period of a year. But we're trying to be mindful of places like HCH, for example. We rent for weddings, and so if we put a quantity, on the number of alcohol special event permits, at that point, the entire point of that establishment is to be able to rent it out. Same things for event centers or banquet halls, as I previously mentioned. So unless we have some other mechanism for allowing those places to have alcohol, right now I think that increasing that fee to make it commensurate with our other partners, our other restaurants and establishments that have the ability to do these catering permits, I think that's going to be the best we're going to be able to do for right now until we get more information on how that works. Next is suspension and revocation, grounds and procedure. So right now, no license can be suspended except for due cause and after a hearing. That makes perfect sense. Due cause does not specifically reference conditions upon the premises which pose a danger to the public outside of regulations related to alcohol, gambling, narcotics, and sex offenses. So we are looking at increasing that. So the amount of CAD calls that we are receiving, or the CAD files and reports and data that we receive, police and fire response, incidents that are happening outside of the establishment that are from individuals that have admitted as part of the report that they were coming from that establishment. We need to be able to include all of those things. And right now, it linking it just to regulations for alcohol and gambling does not provide me with enough confidence that I would be able to, show due cause either in court for a criminal violation or for revocation of that permit. So we need to include those. It also specifies that a hearing officer is appointed by a chairperson of the board, must be licensed attorney, and must be disinterested in the proceedings. We should note that when we get to the end of the year, and we're talking about renewals especially, we're also using a hearing officer if a denial is had and they're entitled to due cause. Hiring an attorney between November 1 and January 1 and making sure that we can get that potentially before the board is extremely difficult. That's really putting a time crunch. You have to respond within 30 days of someone filing a notice of appeal. In light of how we handle our meetings around the holidays, that may not be functional or possible. So to streamline this process, we're asking that the hearing officer be appointed by the board as part of our annual appointment. And with more definition and specifics related to disinterested. In my opinion, disinterested is if you had a conflict as a judge or if you had a conflict as a commissioner, that person would have to recuse themselves. But we need to provide more definition as to what disinterested means, because it could mean anyone who lives within the city of Griffin, in which case we're being forced to pay an out of city or out of county even attorney to pay and do an hourly rate for being able to review the file and make a recommendation, and that's extremely expensive as well. So ideally, this would be the city's municipal judge, and in the event that we have a conflict of interest, the associate judge. That would make sure that we're going to have someone who's going to be here. We know what the holiday schedule looks like for court hearings. We can schedule them with our other court hearings so that Judge Howell or any other appointee that you may put onto the bench has the ability to be able to review these. Other jurisdictions make them all come to the commission, meaning that if anybody is looking at a revocation, a suspension, a probationary license, or is denied a permit, they would come up before this board and you would act in your judicial capacity. So it would be exactly like what we have for zoning, where you were only allowed to consider facts, you were only allowed to consider the law as it is laid out, and you were acting as a judge in that capacity. Again, November 1 to January, I don't think that it's wise for us to load up this board with, potentially a slew of those public hearings. Where you would be required to hear evidence. So we're not talking about a short presentation, we're talking about a full-blown hearing. So this to me sort of fits with what our needs are and fits with what our current operations are with regard to our judges. I think that it's a good solution. Obviously, we're open to any other changes, but I think that that's probably the wisest way to proceed, is if you guys appoint a hearing officer at the beginning of the year. Next is expiration of licenses for failure to commence business. I mentioned this earlier. Currently, if a business fails to open within 6 months after issuance of the license, they automatically forfeit and cancel that license. They don't get a hearing. Same thing if they cease operation at 6 months. Every other jurisdiction that I have found says that if they fail to open or operate, or they cease operations for 90 days, it is automatically considered that their license is revoked. And so I'm recommending that we comply, and set that standard. Next is inspection authority of the city. This one looks like a more substantive change than it actually is. We currently have the ability to inspect any premises for alcoholic beverages at all reasonable times. I'm wanting to define what reasonable times is. So I would like to add that we can inspect at all times during the period that they're allowed to operate the business by law. And that if it is being used after hours by employees, owners, or their agents, that we can inspect then as well. So just because they are closed to the public or appear to be close to the public does not mean that our city police officer or building official does not have the ability to go in if they look like they're operating. So if they're renting for a private event, not open to the public, our police officers should still be able to go in and determine whether or not they're complying with our ordinance. Next is days and hours of operation. So currently, eating establishments and hotels may serve from 11 a.m. As early as 11 a.m. on Sundays. On-premises consumption that includes bars, eating establishments, and your public clubs under the current designation, are permitted to serve from 1:55 a.m. Monday to Saturday and then midnight on Sunday. The tables must be cleared of all alcoholic beverages 30 minutes after that final sales time, which is 2:25 a.m. on Monday to Saturday and 12:30 a.m. on Sunday. That does not mean that the business has to close. There's no indication that they have to close, just that all alcoholic beverages have to be cleared and they can't serve them anymore. So our recommendation is that eating establishments and hotels, we do 9 a.m. to midnight. So your Monday to Saturday is being reduced from 1:55 a.m. to midnight, and then Sunday is 11 a.m. to midnight, which is the current requirement. Other on-premises consumption locations, Monday to Saturday and on Sunday, 12 p.m. to midnight, days of operation allowed only. Tables would need to be cleared of all alcoholic beverages within 30 minutes of that latest sales time, so 12:30 a.m. every day. And we're going to note that bars must be closed for business no later than 1 a.m. Again, bars can only operate within the special entertainment district. It is very complicated for our police department to be able to determine whether or not they need to continue to focus their attention downtown if we can't tell whether or not or when a business has to close. If your primary purpose and function, which for a bar, that's by definition, their primary purpose and function is to sell alcoholic beverages. If they are no longer allowed to do that after 12:30, they don't need to be open. So the opening means that no person must be present on the interior other than law enforcement employees. And it also means that all signs, performances, or sales consistent with operations have to cease. You have to turn off your signs. You have to stop the live music. It really should just be your employees doing what they need to do to close out the shop and get prepared for the next morning. So this is a little bit of a bigger change because right now it's till 1:55 a.m. and you may have businesses operating until 2:25. You may have, continuing having people mingling in the streets and things of that nature. We're wanting to make this easier for our police department based on the experiences that they've had within the last 6 months, which indicate that this has become a problem and they're really having to split their attention. And when you have one business that closes at midnight, and then you have others that close at 1 and others that close at 2, they're staying open, but they're clearing beverages. I mean, it's a lot for the staff to have to go in and determine whether or not there's a violation that's occurring. This evens the playing field across the board. And as someone's very wise mother said, nothing good happens after midnight anyway. So this makes the most sense in our opinion.
Question, are you going to address security at bars and stuff?
Yes.
Is this-
Yes.
Okay.
Yes. So, well, and
everybody needs to be going home by 1:00.
everybody needs to be going home by 1:00 unless you're an employee of the business. And if you're an employee of the business and you guys are locking up the doors, our police officers will still have the ability to come in to inspect to make sure that that's the case, because employees should not be drinking on the premises if they're on the clock. And I know that that is something that bars do. I know that it's an expectation that, establishments have, but that is not, it cannot happen. It cannot happen. It should not happen under state law or our ordinance. So everybody who is there from a public perspective should be home by 1:00, should be leaving by 1:00.
And that's citywide.
Yes, with bars, the 1:00 rule will apply. And that is because bars, the primary function is that they're selling alcoholic beverages. So an Applebee's is going to be required to clear all alcoholic drinks by 12:30 a.m. and they can no longer serve alcohol. But if they wanted to stay open until 2, as long as alcohol isn't being served, they still have the ability to serve food out of the kitchen. Their primary function is not serving alcohol. It is actually operating as an eating establishment. So they still have something to sell. A bar does not. So the security camera requirements will handle security cameras and security. So currently, security cameras are only required for our packaged retailers for off-premises consumption. They're required for our liquor stores. They're required for our convenience stores, grocery stores, and things of that nature. The violations are very slight. If you are cited, you have 20 days to install it and come into compliance. Once you're cited, if you come into municipal court, you can only be charged $50 for your first offense. If you're cited for a second offense in a 2-year period, it's only $100. And if it's a third offense, it's $250 in a 2-year period. Now, the only exception is that you can be charged $1,000 per day if you fail to install it within that 20-day requirement. I don't think this makes sense, considering in order to get the license, our police chief has to say that the placement of your cameras and the sufficiency of your cameras is present. I don't think that this acts as a deterrent, because if I'm an individual, I'm going to be looking at this and saying, in a 2-year period, in the off chance that a crime occurs at my establishment or in front of my establishment, am I going to spend more than $100 on a camera? And if the answer is yes, I'm not installing a camera. So this does not serve the function. These fines do not deter people from violating our ordinance. And so we are asking that those be increased to the maximum fine, the standard fine in the city, which is in section 1-12, $1,000 and up to 6 months in jail. And that's a standard requirement. And that would be for each day that they continue to be in violation. Again, for renewals, our police officers are going to be able to go onto the property and certify this camera meets these requirements. We're also going to be emphasizing that this is on demand. We should be able to obtain this footage within a certain number of hours. If they cannot provide it, they will be cited. Now, your first circumstance, we can do an adverse action, which is just a written warning saying you need to get into compliance. Here's your citation. But if it's happening more than once, and I don't think we should limit it to 1 year or 2 years. If it's happening more than once, at that point, they need to be coming in to be considering whether or not their license needs to be suspended for a particular period of time until they can come into compliance. So failure to maintain the cameras, as I said, can result in an adverse action against the licensee. Citations plus possible suspension, revocation, or sanction against the licensee with minimum fines increased. And the big thing here is that we are also going to be requiring these for bars. This is done in other jurisdictions. I have no clue why it is not a requirement here. We are one of a few jurisdictions within our area, including Noonan does not allow bars. Stockbridge does not allow bars. Every bar you see in Stockbridge is a bar and grill. They are operating as an eating establishment, 50-50 food. The bars here are not required to serve food. Some do, but they're not required to serve food. And at that point, you're operating with the specific intention of serving alcohol, just like a package store. We've got to have cameras. So we're going to be requiring those on the inside as well as on the exterior so that we can monitor. It will assist our police department in being able to solve crimes. And it will actually help, in my opinion, for these businesses to be able to tell who their troublemakers are, so that they can determine whether or not they want to include them in their business, whether or not they are not permitted on their premises. And speaking with our police department, they indicated this was a standard requirement for other locations, including Mama's and Country Rock. And so we are much smaller, we're much more congested, and we have much more traffic going down through downtown that's closer to these businesses. And so I think these cameras are a necessity. Next, we have bars, bouncers, and post officers and post-certified officers required. So right now, bouncers are not explicitly required in the ordinance. It doesn't say a bar must have a bouncer. Current code just states that the licensee is required to maintain order. They have to verify age for admittance, and they have to ensure that their occupancy load is not violated. Those businesses have chosen to appoint a bouncer, and the definition of bouncer includes someone who's going to be checking the occupancy load, checking IDs, making sure that the people who are getting rowdy are escorted out. Our recommendation is going to be that from the hours of 7 p.m. to the close of business, all bars. So again, that's 7 p.m. until 12:30 or until 1 a.m. for the bars. They're required to hire an off-duty, pro-certified City of Griffin police officer. So we are imposing a requirement that it be a City of Griffin police officer unless one is not available, in which case they can hire an off-duty deputy from the Spalding County Sheriff's Department. Our rationale for limiting the type of officer or security that they can have is due to our officers having knowledge of the city's ordinances, of having knowledge of what's in this alcohol code, what's permitted, our policies, our chain of command in the event of emergency, our emergency protocols. And past events have shown that even hiring a Spalding County Sheriff's officer creates some issues because there's questions as to jurisdiction. And so if a sheriff's officer is on site and they're calling 911, often they may not respond until a City of Griffin police officer, gets there, and it creates some confusion as to who is responding. So what a Spalding County Sheriff's officer who's off duty hired for security may have said is imprinted upon the City of Griffin police officer who arrives to respond to the complaint in the first place. So we're trying to cut out all of the confusion. We're trying to make sure that if an emergency occurs, we know exactly how to respond. We know dispatch knows who to contact. And again, this is not all day. So an establishment that is open as a bar at 1 p.m. for a football game, is not going to be, having to hire that person until 7 p.m. So it's going to be between the hours of 7 p.m. and 1. And they do have that backup option of the sheriff's department, but we just want to make sure that it's only if a off-duty City of Griffin police officer is not available. This mandated officer is not a substitute for a bouncer. They are not going to be shall not be responsible for verifying age of admittance. So they're not responsible for checking IDs, and they're not going to be responsible for maintaining the number of the occupancy load. Okay, so they are there for security. They are there to monitor and determine what violations exist. That business still has to be responsible for ensuring that their occupancy load is not violated. Okay.
And a bar versus special venue. So special like a Putt and Pour, right? Don't have to have
Putt and Pour is considered, or under this would be considered, an art and recreational establishment.
that's not required.
Yes, those would not require, and that's again the primary issue here, and the reason, the rationale. We're relating it back to our police powers and relating it back to public health and safety. A bar's primary reason for operating is that they are selling alcohol. That is the existence of their business, the purpose for which it exists.
How many bars do we currently have downtown?
We have Tipsy Daisy. Well, currently Tipsy Daisy is listed as a public club. Under this new designation, Tipsy Daisy would be considered a bar. So it would be
margaritas and that.
Yes, and that would be it. Those are our bars. Everywhere else is considered an eating establishment or a public club, and under the current designation would continue to be a public club. Or, an art and recreational entertainment establishment.
Let me use for that if a city of police officer is not available, what would deem him to not be available? You say
If the owner of the or whomever from the business comes to the city of Griffin Police Department, there's certain protocols, what we call extra duty or part time. And so if they reach out and Lieutenant Walden handles that for us, and he says I can't get my to work tonight, then go to the sheriff's department. It's not simple.
And they have a similar process.
so that this it would be week by week or
A lot of times, I would assume under this new requirement, they could just go ahead and set it up, and sometimes the officers say, "Well, I want to work this," and so they work it. And if they can't work that weekend, then they have somebody else do it. But it's up to the owner if he wants to do it week by week, or I mean, it's going to be required. I wouldn't recommend that. I'd go ahead and get a schedule together.
right. Well, the reason I asked, I think before with Chief Yates, the officers didn't want to work the bar. They refused to work the bars. Are we now requiring that?
Well, that's why we put it in there that you'll have to compensate them so that they'll come work. But if we don't want it to just be our police department that you can go to, you have to go to them first. If they say no, then you can go to the sheriff's department.
Yeah, so that was put in there specifically to make sure we had a backup option, because we don't want it to be where a police department can, refuse to work and therefore shut down a business because they've refused to work. That's not going to be the case. The sheriff's department is a substitute.
None of our officers and other sheriff deputies want to work that particular location, basically blackballing that establishment.
If that were to happen, we would have to open that up to look at. As of right now, we've never had an issue with someone from the sheriff's department working these locations.
Well, I think that they would have to close because otherwise they don't have a post-certified officer. So if you're changing your ordinance, so you have a post-certified officer
Under the current
but
code.
cannot.
But
But
they have
county,
no authority.
no, they have no authority.
So
So
you're
currently they
working
could hire Butt County, but right now, if we change it, when our recommendation is to change it, we need somebody that can have arrest powers here on premises. And so no, they're either going to increase their costs because they want to work them. They want to work them for $30 an hour, but they want to work them. So they'd have to increase their costs or have to close it shutting down tonight.
And it's a free market when it comes to these types of jobs. So, Hobby Lobby, hired someone to go out, and our police officers worked that for an extended period of time. I believe they had a longer schedule that was put into place as well for those officers to work. But there are certain jobs that are coveted because they do pay well, and they pay commensurate with what the expectation is of those officers to provide that security. So yeah, I mean, if that were to happen and you had concerns that it was just we're just doing this with the intention of blackballing the business, then that's something that if you wanted that to change, it would have to come back before you for another ordinance amendment. But in truth, if you have a city of Griffin, an entire department, as well as an entire sheriff's department that are indicating that they do not want to work a location for whatever reason, that indicates a problem. And at that point, I would venture to guess that there would already be adverse action. Yes, there would already be adverse action taken to make sure that we're either doing a suspension, revocation, or an action plan to address the concerns noted by those officers or deputies. Oh, there we go. Okay, so bars are going to be required to provide a current occupancy on demand of the fire marshal. So currently, the licensee is required to maintain compliance with their maximum occupancy that's approved for that establishment. The fire marshal has the authority to determine that compliance based on visual inspection of the premises. This is just an eyeball. He goes in and he looks at it. I will tell you that I am forever amazed at Chief Hamilton's ability to be able to look at a room and tell you exactly how many people are in there just by eyeballing it. It comes with time. It comes with expertise. But when you have a very crowded room, it can be difficult. So we are recommending that bars be required to utilize a fire marshal clicker or other mechanism by which the bouncer can track the occupancy within the establishment. A clicker is truly just it's like a step counter. Imagine it like that, where you have one for people coming in and one for people coming out, and the combination of those two should be able to get you the current occupancy, or a very close estimate that's not just an eyeball estimate. So the licensee or their designee bouncer must be able to provide a current number of occupants on demand from the fire marshal. So if Mike Thompson goes by and says, "How many people do you have in here right now?" and they give him a number, he can look at the eyeball it, and if he determines that is patently false, or if they say, "I genuinely don't know," maybe 50, maybe 100, and they can't give you a number, that's an indication that we have a problem. You're not taking in, making an effort to be able to come up with that number, to be able to track it. This is standard protocol for a bar, especially for, like I said, we have other jurisdictions that are larger than ours that don't even allow bars to exist. And so I think we're within our rights to tell them that if you're going to operate and you're going to have a lot of people coming in, you need to know whether or not you've reached your occupancy load and you can't have any more people in here. It is a major safety concern, between people being trampled, between there being, if there were a fire emergency, to if there's not enough room for people to dance, you're looking at potentially creating fights or other violent outbursts. So they need to be able to know that number. It doesn't necessarily have to be a fire marshal clicker. If they want to have some other technological mechanism where it's tracking people walking in the door, then so be it. That's fine by us as well, as long as they have a mechanism for being able to provide a number on demand. So again, notwithstanding the occupancy number, the fire marshal has the authority to determine compliance via visual inspection, and will be notifying us if they believe that that load is being violated or if the person can't provide a number to us. Next is pricing, advertising, and service limits. I am very fond of these, in part because I think we have been very lax in the types of advertising that we allow with regard to bars, and alcohol in general. And these are requirements that are best practice if you take a tip certification, which is the common certification that bartenders are required to take, or that many businesses require their bartenders to take before they can serve. A tip certification is going to tell you that these should be your standard rules. And the reason why is that we have dram shop laws. We have it where a bar or a business, including the person who served as well as the owner of that business, can be held liable if they serve someone and then that person gets in a car and ends up killing someone else. They can have liability on themselves. Unfortunately, there is that's all civil liability. There can be potentially criminal liability if you contributed and the police department can prove that, but that doesn't speak to your alcohol license at all. It's really an after the fact, after someone has died, after an injury has occurred, after someone has been severely hurt because of how someone chose to market and sell their alcohol. That's when we're acting, and it provides us with no authority to be able to enforce that. And so I believe that we have an obligation to set the standard, and make sure that if we're not going to require proof that their employees are trained, then we're going to be holding the licensee accountable for how those employees serve, as well as what they post on their Facebook as far as what their deals are for the day. So these are standard best practices, and they're also requirements that are imposed in other jurisdictions, including Sewanee, as well as I believe Savannah also has this. And you may be, look at this and say, well, I've seen other people violate that. And right now, what I'm telling you is we need something to be able to enforce it. We will be enforcing it going forward. So if you see it, please let us know. The recommendation is that no licensee, employee, or agent of the licensee, and this is all actionable against the person who holds the license, can offer or deliver free alcoholic beverages to any person or group of persons, deliver more than 2 alcoholic beverages to any one person at a time. That is a way to prevent you from selling to underage individuals if you're not, and this would apply to any restaurants and eating establishments as well, not just for our bars. But if someone orders 3 drinks and they go sit it down at a table, you haven't carded the third person at the table. You don't know whether or not that person's under 21. That's why that's best practice. Offer to sell, which means market on Facebook, or deliver any alcoholic beverage at a cost less than regularly charged during that same calendar week, except for private events. Offer to sell, or deliver drinks at a price less than those offered to the general public on that day, so making deals for friends. Offer to sell, or deliver alcoholic beverages, including malt beverages or mixed drinks, by the pitcher, except to 2 or more persons at one time. So if someone is ordering a pitcher of margaritas, there should be at least 2 people there to consume them. The rationale is that under your best practice for your tip certification for a bartender, they're allowed to turn down service if someone orders another drink. Once you give them a pitcher, you can't turn down that service. You can't take half of it back. They've paid for it. So this ensures that that employee and that agent are required to monitor someone's intoxication level and can't rely on the fact that, well, I gave them a pitcher and they were fine halfway through it. Next is offer to sell or deliver distilled spirits by the bottle. This should only be something that package stores are doing for off-premises consumption. There is not a circumstance where I can think that it would be wise for someone to be able to offer or to purchase an entire bottle of liquor for their table. Because again, the bartender cannot monitor that. We're asking for someone to serve someone who's already vastly intoxicated because you can't tell who's drinking it. You can't ID them. You can't tell when they've hit their limit and then they're potentially leaving the establishment after that. And lastly, encouraging or permitting any game or contest involving the drinking of alcoholic beverages or awarding alcoholic beverages as a prize. Building requirements, they must comply with building and fire code. But again, there's no mechanism for outside of our certificate of occupancy. We're requiring COCC or other planning and zoning letter. Also requiring that no screens, blinds, curtains, or partitions or other things can obstruct the view of tables, booths, or other areas where customers are served and or sit. Obviously, there have to be blinds, like for eating establishments, if there's the sun. So this one is not as strenuous as our package dealer. It's just that you can't be creating booths where people are blocked off. If a police officer or a fire person walks in, they should be able to see the locations where people are sitting. If you have a separate room, the same would apply. So those separate lounge areas need to be a part of the places that are being served. So you can't purposefully put up curtains that can block the booth or seating area from view. Order required on the premises. So we do have something along these lines. They can't have any disturbance of the peace or they can't knowingly allow someone to disturb the peace or act in an obscene or publicly indecent manner. And then repetitive breaches in parking lots can be actioned against. Our recommendation is that we specify this a little bit more. I love Sewannee's order required section, which provides that owners, managers, and employees are responsible for keeping an orderly place and can't permit an employee, patron, or other person from engaging in loud, boisterous, lewd, or obscene conduct or practice within the establishment. And that the owner and manager are also responsible for monitoring the parking lots or other areas outside. And that they can prevent persons or shall prevent persons from standing, sitting, mingling, or assembling outside in a manner that causes or contributes to disturbances or illegal acts. And so that it really puts the onus on the owner and manager who has that license, where they can't just say, well, they were outside of my business, so it's not my problem. At that point, if you know that people are congregating outside of that area and you know that they're either coming back into or waiting to come back into your establishment, we want to make sure that you're responsible for ensuring that those people aren't acting in a disturbing manner. Yes.
The jurisdictions that we're looking at, are there any closer to us?
Yes, so I only listed Sewanee because of their similar size and the fact that they allow bars. Majority of the ones that are closer to us do not allow bars at all, including Noonan, Stockbridge, and
Does McDonough allow bars?
McDonough does currently allow bars, I believe, but their ordinance was modeled in part after ours, so it's a match. It's an exact match because Drew also helped assist in writing that one with a few exceptions and changes, but I do believe that they currently allow bars. What was that? I've not looked at Forsyth, but I don't think that Forsyth does. I have another list in here. Actually, here we go. Let's see, bars. Retail bars on premises. Stockbridge doesn't allow, Noonan doesn't allow, Thomaston doesn't allow, Sonoya doesn't allow, Woodstock does not allow. And then Dahlonega, I already covered Noonan, I already covered Stockbridge, and Carrollton do not allow. And that's a pretty, a pretty wide screen. But I would say that when I look at the framework, if you're looking at one that allows bars and is of our size, which McDonough is not necessarily, Sewanee is a really good example because they're just under, or like right around the exact same population that we have, and they have downtown pubs. So their bars are also limited to their special entertainment district. They're not abroad. They're dealing with issues of congestion, like what we have downtown in the special entertainment district, where you have a road right next to a very small sidewalk space, and then there's your business. That's primarily where theirs are also operating as bars. I believe that they call them pubs, but they're like downtown pubs who exist for the primary purpose of providing alcohol, and they serve things like pretzels and things of that nature. But everywhere else is you're looking at also having a restaurant, so you're patting people with food on top of the alcohol that you're serving them, which I think kind of really changes the calculation. I know it changes the calculation for our police officers even when they stop people, because that contributes to your blood alcohol content. So I mean, all of these little factors, it seems silly if they have food that we would treat them differently or that we wouldn't consider them to be a bar, but it makes a big difference with regard to how alcohol is looked at by the state. So,
Okay, I got it. Okay, like all the new rules and regulations, stipulations. Okay, like downtown, smoking margarita.
Mhm.
Has very large. Five, it has a very large.
Mhm.
And but those are considered bars, right?
They are considered bars, yes.
And what's the other one?
Tipsy Daisy.
50 days. They have entertainment sometimes, right?
Mhm.
Okay, now when Doc Holidays was open,
Mhm.
they had a very large. So I just is it the reason because of the two clubs to have the big crowd that you want to change? I know you want to keep everybody, every citizen safe,
Mhm.
and also the police safe. And I mean, is it because of those two clubs because they have the most crowd? Now I don't know if like anybody are getting hurt downtown or whatever, but are those two clubs the reason for all the changes?
It is not the reason for all of the changes. So since I have been here since 2021, alcohol code has been on the docket for making amendments. It has been on here for 3 years. I'm going on maternity leave, so I was told that you better get it done because it's getting done this year. Now, I will let you know that since we have had an administration change with the police department, the communications that we've had from our officers when we say, what issues are you having? That's the response that we're getting. It's really, there's more dialogue now for us to be made aware. We have major concerns. If Doc Holidays was open, I can absolutely guarantee you that this was a problem there as well that needed to be addressed when that was open 2 years ago. Tipsy also has an issue with some of that overflow, especially because they have live entertainment there. And so when people spill out into the street, if they're acting in a manner that is requiring a police presence and response, then that should be on that licensee. It should be on them to be able to respond. Tell that post certified officer that will be required. We need these people escorted off the premises. Or that they need to leave, or we need this broken up, or I have concerns. We want to make sure that they're doing everything in their power, not just to make the money by selling the alcohol, but to make sure that they're being good stewards in our downtown. So a lot of that has come from a police response, especially within the last couple of months. I'll let you know we've had a detail downtown due to complaints that we've had from citizens as well about kind of what's happening. And that overflow is really there's a high risk there. There was a shooting that occurred, and there's confirmation that the shooting occurred for people who were leaving, local establishments. So I would not say that it is related to any one business. It's related to to a business operation, namely bars. But I will say eating establishments can be just as guilty. So an eating establishment that's outside of the special entertainment district that does have a high volume of alcohol sales is Kevin's Corner, which while they are an eating establishment, they do have some police response. And so the same thing would apply to them, that they're going to be responsible for people who may be out in the parking lot, causing issues and causing disruptions. And they're going to need to do what they need to do, including potentially calling the police department. So if they need to call for a response, they need to call for a response. And this puts that on them.
Okay, now what about the brewery?
The brewery is going to be considered a brew pub. I believe that's how they're currently licensed. So they are considered a 50%. What was that? Only one of them has a license. The other is still being looked at. Yes. And the other will have on premises, but we're still looking at how that one is going to be. Yeah. Yeah, we're still looking at how that one's going to be laid out.
Okay.
Karen just emailed you about that yesterday, I believe. And we're in communication with the team for the other brewery. But as far as Piedmont goes, they are considered a brew pub, so they are 50% eating establishment and a manufacturer, and so they are just as responsible for making sure that their outside premises, that these people are not acting in this manner. Now they're not required; they may, but they're not required to hire an off-duty police certified officer. But they are still going to be required to maintain order. So if they need to call the police department to respond, they need to call the police department to respond. And if when we get to renewal time, we find out from the CAD files and the report in the file that Ms. O'Connor's looking at that we have had 10 police responses within the course of a month, that's an indication of a problem. And at that point, we can do a probationary license with an action plan. So all of this is intended to make it where we have more than just revoking a license and shutting a business down, where we're giving people every opportunity to be able to maintain the business the way that they need to. And if they're not, to give them the option of remedying that, to put into place safeguards to make that happen. We're a little bit more strenuous on bars, and that's because it is a major privilege to be allowed to operate a business whose sole function and purpose is to intoxicate people. I mean, that is a major privilege that is being given. That people are listening to live music there. They may be listening to entertainment, but they're not there for the entertainment. It's not like it is with the opera house where someone's going to watch, someone hired, a live musician who's hired, or a cover band, or a theatrical production. Someone is going there specifically with the intention of drinking and socializing. And we want to make sure that the regulations we put in place are not going to that our citizens aren't being burdened by their privilege. So that's what these are intended to be about.
Our bars are closed at 1 o'clock.
All bars will close at 1 o'clock, and like I said, there's only three.
Yeah.
So
Okay.
yeah.
You got to be cautious, so we're trying to make the license responsible for outside activities. It's the distinction between what's public property, what's private park lot, or even in a shopping center, where you've got more communal private property.
Yes.
It's shared between tenants and whatnot. We did have an instance with Scott Holiday several years ago where there was somebody camped outside on the street, and the police actually apprehended the guy for approaching. We never could show the person that is Doc Holiday, although they had been drinking, using drugs.
That's why
Yeah.
they'll have to have security now.
Yeah.
Right.
So that's why.
To see when they exit, where they exited from and what condition they were in.
Yep. And from my perspective, if a person could civilly sue the business for serving alcohol to someone who went out into the parking lot and caused harm or injury to someone else, if they could civilly be sued, we should be able to act against that from our license perspective as well, or at least note it as an adverse action to be able to say, look, we're noticing that people who are leaving your establishment, often it's people going outside to smoke. So if someone goes outside to smoke and they have every intention of walking back into that business and they are committing a crime or acting in a way that is disturbing or contributes to illegal acts, at that point, that business is they are there for the business. They're not there for our accommodations in our alley or for our parking lot. They are there for that business. And so they have a responsibility to be able to monitor and be aware. If they have a problem, all it takes is calling the police department. Unfortunately, these types of businesses are notorious for not wanting to call the police department. They don't want to lose business. People who come to the locations for a bar, my mom's a bartender, they don't want to call the police. They don't. And so this really puts it to say that if you're not going to call the police, you're going to be held responsible, because it couldn't be as simple as calling and saying, this person needs to leave my premises and cannot be here. They're now trespassing. But they have to be able to take that initiative to trespass that person themselves.
All right, we've got 2 more slides. So it is 10:33. We
roll.
still have 4 more agenda items. So let's get through these last 2, please. And we're going to give you this presentation. It will be on the agenda for October 8th and whatever that is.
Yes.
And so we will be happy to answer any questions you may have, but let's get to these last 2.
In light of the short requirements, if you do have anything like Mayor wanting to know about the regulation for distances, if you have any specific question about what's in here, please email me so that I have the opportunity to research and I can meet with you one-on-one to discuss what your concerns are and make sure that that's incorporated into the draft, because we do have that short turnaround time. So the last thing is more of a reminder and less about what we're putting into the code right now. It's a reminder for state law with regard to smoking. So the Georgia Smoke-Free Air Act was put into place in 2005, which prohibits smoking, which includes now e-cigarettes as well as water pipes and cigar smoking in any enclosed area that, within a place of employment unless it meets one of the exceptions. Bars and restaurants are an exception, but they have parameters put in place. So all parts to which access they can smoke in all parts to which access is denied to someone who is um, under the age of 18 or under the age of 18. So you'll see those signs posted. And it also must be in a private room within the restaurant or bar if the rooms are enclosed and have an air handling system independent from the main air handling system that serves all other areas of the building. And all air within that private room must be exhausted directly to the outside. A good example of compliance with this is Buffalo's. Post 2005, they set up that independent room. They have a separate air handling system that filters out the smoke to the outside, so they've invested in that. That makes it where that is in compliance with the law. Again, this includes cigarettes, cigars, pipes, e-cigarettes, and water pipes or hookahs. And restaurants or bars who create those enclosed spaces are required to keep a written statement, state law, that they're from the air contractor that shows that that system meets the requirements of state law. In addition to the fire code, all of our alcohol licenses are conditioned upon your compliance with federal, state, and local laws, and failure to abide by that state law is grounds for suspension or revocation. So I'm noting that this has not been something that has been, largely enforced where we're going and we're asking for this documentation. I do think that we should. I think that times are changing. The city of Savannah does not allow smoking at all in any of their public establishments. I mean, you're looking at a location that exists again to intoxicate people, where you have a lot of people who are going and drinking, and that's part of their economic development driver, and they do not allow smoking of any kind with the exception of outside areas. It cannot be within a building. So this may be something that we need to target later to look at whether or not we have a problem. From a code perspective, to do a Clean Air Act, what a lot of municipalities and counties have done to prevent this type of business from taking place. And it would also apply or go hand in hand with any sort of vape shop ordinance that we may institute. So I just want to put this at the forefront of your mind, and then also remind all of our businesses that this state law does exist, and it is a cause for revocation of your license if you're not purchasing and installing these types of air handling systems. And then lastly, we're going to add a code section for the Griffin Golf Course, because most other jurisdictions that have public golf courses, just to specify that they're permitted, have it in their code. We're granted a state license, so we have always been operating legally. But I just want to make sure that it's noted within our code that we have an employee who can apply for and obtain as an agent as part of their job description this alcohol license, but nothing will relieve them of the obligation to make sure that they're complying with all the requirements of the law we currently have and what we currently do. So that's just more of in technicality, making sure that we are coming into compliance ourselves and putting everything out there about the fact that our city golf course does have an alcohol license. Any other questions?
Let's start from the beginning.
Thank you for your thorough explanation. It's crystal
Thank you
clear
guys for
what we
being
can and can't do. It makes me never want to have an alcohol. Red beer. There was not a red beer ordinance for Mr. Petty on golf course.
No, there it is.
There needs to be. Only one beer. All right, moving into item 2, a fifth yard waste audit, proposed yard waste policy and ordinance amendment.
Okay, so this can be very brief. The update is we don't have a policy yet. That is because when you dig into this and how we charge for solid waste services in general, we don't think it's consistent with what actually is happening on the street. There's a lot of different reasons for that. I will tell you that just as recently as yesterday, Ms. Bagwell and Ms. Hawk spent over 6 hours going through the garbage yard waste disconnect. So we are a combined utility system. We should not be allowing garbage and yard waste to be disconnected at any time. However, we have in the past. And so one of our recommendations is going to be to stop that, because what happens is we have a very transient population. somebody moves out one day, and so the property owner comes in and says, well, I don't want to pay garbage and yard waste and mark nobody living there for the next month while I rehabilitate the house, which is fine, except that normally it's only a week or so, and so somebody moves back in. We don't even have the ability or time yet to go out and collect the containers, and so we've turned off garbage and yard waste. The containers are still there. The person moves in a week later, and they get free garbage and yard waste. It's a huge problem. 6 hours for a quarter of the report yesterday, and we still haven't determined what exactly that looks like. So this has become not just a yard waste audit, it has become a complete solid waste audit, because what we're also trying to do is make sure that enforcement is consistent and not arbitrary. And one of the suggestions at first was to create a definition for an individual yard. However, when you start actually driving around the city and you look at what an individual yard may be, it is almost impossible to define, because you may have a 4-unit apartment complex that all has yards, but is an individual yard if there's not a fence in between the different units? Maybe not. I don't know. Do they have yard waste? Maybe. It depends if there's a tree or bushes or whatever else. So that hasn't really worked either. We are hoping that it is going to be based on individual carts. So we do have garbage that we charge an apartment rate based on it having so many units and so little yard waste space that they all have a dumpster of some sort, versus apartments that have actual carts, green and blue carts. And so if that can be consistent with who would and would not have yard waste, I think that would be the best way to determine who does receive the service and who needs to pay for the service. Because right now we know for a fact that people that don't pay for the service receive the service, but also some that pay for the service don't receive the service. And so we want to get it right. And so I apologize that it has taken this long. I can assure you that since July we have been working on it. It's just that it's a little bit of a mess. And we want to make sure that when we come back to you with a policy, it is the correct policy consistent with what we're actually expecting of our employees and our citizens on the street. So that is where we are. Rita and I are scheduled to meet next Tuesday to go over what all they have found. She hopes she and Claire can have the audit done as far as the garbage stuff now by then, so that we can figure out if we have any kind of consistency, and if not, what is the best way to define and clarify what that is. So that is where we are at this point. I'm happy to answer any questions if you have any.
Any questions?
Okay.
All right, moving number 3, I take the in-house compensation study and potential amendment needed to the pay scale as a result of the study.
All right. So my number that I gave y'all a few months ago, was about accurate. It has come out to $2,512,500 in wages alone. You add about 40% to that for your benefits. So you're looking at over $3 million. We don't have finalized numbers yet, because Ms. Woods and I have not had a chance to sit down, but I can give you a little bit of some information so that you know where we're headed. This gives everyone at least a 2% increase. Generally speaking, the lower the grade, the higher percentage increase. So what we are going to propose is that our minimum pay for non-public safety positions goes from $13.50 to $15 an hour. Right now, the county starts at $14.42, so that would help us with our minimum pay. Fire, for instance, would go from $13.48 to $16.17 per hour. The 20% increase, but it's barely above what Spalding County is paying. Minimum pay for police would go from $49,167 to match what the sheriff's department is paying, which is $61,500. That's a 25% increase. But I can't not do it when they can go across the street and make that money. That is sort of the base that I can give you right now. There's a few more that we're going to have to look at, sort of because of seniority and because of when people got promoted. You really can't have a lieutenant make more than captain. So there's some one-offs that we'll have to address. But wanted to give you that information right now. We hope to come back at the October 8th meeting and give you the pay scale to adopt. What we're looking at is the same way we did it last time, which is bringing everybody up to the minimums of the new pay scale and then putting them in their range as they are now. So for example, if you're in the bottom pay scale at $13.50 an hour, but you're 10% into that, so you're making whatever that is, $14.85, we're going to make sure that you stay 10% into that new minimum. So at 15, you're going to make $16.50. Does that make sense? Okay. So that is how we're looking at it now too. So not only do you go to the minimum, you stay within that range where you are, which will also help with compression. But we will have that back to October 8th. I would like to make it effective October 1st and then get it on the paycheck as soon as we can so that our employees have an opportunity to have that money before the holiday.
Any questions?
Kinsley?
You said you'd have effective by October 8th, it goes into effect October 1st?
Yes, we would like to
Oh,
back it.
retro, okay, all right.
Yep. And because of how I get paid, I might actually change that, but we'll figure it out.
Okay. Moving to item 4, receive comments regarding the resolution to adopt 2024 calendar year tax millage rate at the rate 6.254 mils. Is this a public hearing? 'Cause-
It is. Receive comments.
So do I need to call it into session a public hearing or?
You have that saying we're receiving comments.
Okay, perfect.
So I'll make my presentation
Okay.
first, just like we would for any
Yep.
other public hearing, and then we will, you might have the comments.
Okay.
And this has actually changed a little bit based on some communications that I've had with our finance department. We think that we can take the rollback rate this year. And so I'll give you the information that we have so you can see what that looks like, and then we can have any questions, anything else after that. As you can see, from 2014 to now, we have reduced our millage rate by almost 3 mils, about 2.5 mils. So right now, the rollback rate would be 5.893 mils. Last year was 6.254. You also took the rollback rate last year. It was a much bigger impact to the budget last year than it is this year. So in looking at the digest from 2023 to 2024, it increased a significant amount. So with reassessments and other changes, it's 116,736,386 in 2023 versus 87,341,441. So that's what gives you that rollback rate to keep a consistent taxable amount at the end of the property taxes. What that looks like for us, again, in doing this presentation, if you cut the current rate at 6.254, this year we budgeted $4.6 million in property tax revenue. If you collected 100% of your property tax, you'd be over $1 million good. We don't collect 100% of property taxes. We average about 90%. So if you cut the current rate, that would bring in $5,233,895. So you'd be about $633,000 over what we budgeted. If you take the rollback rate, you're still going to have a surplus of $331,779 from what was budgeted. I will enunciate that because you actually have a budget amendment on the agenda tonight that is increasing the budget because of our increase to our GERMA insurance since we increased that liability. So it does give you a surplus. However, what we have learned is that we do have money in what we call Georgia Fund 1. It's an investment account. It's our sales tax revenue, and so we do believe that we can pull money from there to make sure that we have our compensation study adopted. And so that is the recommendation at this time. And I can have any questions, or we can take comments from the public if there are any.
Any questions or board?
So the recommendation is to roll it back.
To roll it back, it would still give us that $300,000 surplus what was budgeted. And then we would also have to take the money, though, for the compensation study from your Georgia Fund 1, which is fund balance. So you're taking it from that fund balance. But at that much, you're going to have to increase your millage rate up to almost 9 to cover the compensation study. I do not recommend that.
Okay.
This is a public hearing. Is there anybody in the audience that has any questions or comments in regards to this recommendation? Okay.
Mayor, because
Yes.
that recommendation has changed, we do not have to have any further public hearings. So tonight, I would ask the agenda be amended to adopt the millage rate rather than waiting until October 8th. And then we can remove the public hearing.
That'll be Ms. Holmes very happy to speak to them.
She'll have her
Tax
numbers
bills and all we go.
this evening if y'all approve it.
Anybody have any objections to that? Very good. Perfect. Moving into the item 5, consider an executive session within the CPA section 1421 purpose, consulting and meeting with legal counsel pertaining to pending and potential litigation, settlement claims, administrative proceedings, or judicial actions brought by or against the agency or any official officer or employee or in which the agency or any officer or employee may be directly involved. Do we have a motion? Mr. Tinsley with a motion, second by Ms. Ford. Please join us in the room.
that's your What? Gosh, it's cold in here. I cannot. I'll be right back. Go! It's something to eat. I'm fine. We're having a break.
Recording in progress.
All right.